supporting million तो इस तरीके से आ जाएगी ये वहाँ थोड़ी सी चीज़
So it won't be there.
Good morning all of you. Welcome. आज ह्युमन राईट्स आणि लॉवर आम्ही एक सेमिनार ऑर्गनाईज केला आहे नागपूरमध्ये स्पेशली लॉ स्टुडंट्स ऍक्टिव्हिस्ट आणि लॉयर्ससाठी जेणेकरून आम्ही एक आउटलाईन देऊ इच्छितो पूर्ण टॉपिक्स बद्दल कव्हरिंग ह्युमन राईट्स आणि त्यांच्या इश्यूज बद्दल. तर त्याच्यासाठी आमचा 2 दिवसाचा प्रोग्राम आहे आणि त्यात आम्ही बरेचसे टॉपिक्स कव्हर केले आहेत जे तुम्ही आपल्या स्केड्यूलमध्ये बघू शकता. आपण सुरुवात करू इंट्रोडक्टरी रिमार्क्स पासून की मीटिंगचा आउटलुक काय आणि ऑर्गनायझेशन HRLN बद्दल आणि मीटिंग आम्ही कशा प्रकारे कंडक्ट करू, काय काय टॉपिक्स कव्हर करू आणि या सगळ्याबद्दल. इथे डायसवर बसले मिस्टर कॉलिन गोन्साल्विस सिनियर काउन्सिल सुप्रीम कोर्ट आहेत आणि मिस्टर धैर्यशील पाटील एक्स मेंबर ऑफ बार काउन्सिल आणि मिस्टर गोकुलवार हे फाउंडर मेंबर आहे आम्ही आमच्या आरोग्यासाठी. तर मग मी हँडओव्हर करते मिस्टर गोकुलवारना स्टार्ट करायसाठी.
सगळ्यांना मराठीत काही अडचण नाही ना? सगळ्यांचं स्वागत. आज ही कार्यशाळा आपण ह्युमन राईट्स अँड लॉ या विषयाला धरून ठेवलेली आहे. ह्युमन राईट्स अँड लॉ नेटवर्क यांनी मुख्यतः याच्यात हे कार्यशाळा आयोजनाच्या मागं त्यांनी सगळं परिश्रम घेतलेला आहे आणि आम्ही आमच्या आरोग्यासाठी आमची संस्था ही मागच्या 24 वर्षापासून गडचिरोली जिल्ह्यामध्ये ह्युमन राईट्सच्या इश्यूजना, डायव्हर्स इश्यूज, फॉरेस्ट इश्यूजला घेऊन काम करते आणि ती याच्यात मदत करते. तर मुख्यतः ह्या कार्यशाळेच्या मागचा उद्देश असा आहे की नवीन सगळे जे आता LLB करत आहेत, काही LLM झालेले आहेत आणि बरेचसे वकील असे आहेत की वेगवेगळ्या ठिकाणी आपल्या ठिकाणी प्रॅक्टिस करताना या ह्युमन राईट्सच्या प्रश्नांना घेऊन बऱ्याचशा आंदोलनांमध्ये मदत करतात. आम्ही सुद्धा वेगवेगळ्या आंदोलनात आहोत, तिथं अशा वकील लोकांची बरीच मदत होते आणि याच्यावरती पूर्ण स्पष्टता मुख्यतः आता जे फायनल LLBला आहे किंवा आता LLB करतायत किंवा जे झालेले आहेत त्यांना या सगळ्या ह्युमन राईट्स बद्दलचा कॉन्सेप्ट एकूण काय आहे हा समजावा आणि त्यातनं काहींना प्रेरणा झाली या सगळ्या ह्युमन राईट्सच्या इश्यूवर आपण पुढे काम करावं. तर त्यासाठी ही समज वाढणं आणि पुढे त्या सगळ्या कामात मदत होऊ शकेल ज्यांना याच्यामध्ये आवड असेल त्या उद्देशाने ही कार्यशाळा प्रामुख्याने आपल्या विदर्भात ठेवलेली आहे आणि पुढे नागपूरमध्ये याचं एक केंद्र अशा दृष्टीने ऍक्टिव्हेट व्हावं चांगल्या रीतीने. त्याच्यामध्ये पुष्कळजणाला या विषयांना धरून अभ्यास करता येऊ शकतो, प्रत्यक्ष कृती करता येऊ शकतो. तर त्या दृष्टीने या कार्यशाळेचं आयोजन केलेलं आहे. मुख्यतः आपल्या संविधानातल्या भारतातल्या संविधानातलं 21 जे कलम आहे त्याच्याप्रमाणे प्रत्येकाला जगण्याचा अधिकार आहे हे आपल्याला सगळ्यांना माहिती. कारण आपल्याला मरता येत नाही, म्हणजे सुसाईड केलं तर तो गुन्हा होतो, बरोबर आहे. त्याच्यामुळे जगण्याचा अधिकार आहे. पण त्या जगण्याच्या अधिकारासाठी जेव्हा तुम्ही जगण्याचा अधिकार एखाद्या संविधानामध्ये आपल्याला मिळतो तेव्हा त्याच्यासाठी लागणाऱ्या किमान गोष्टी ज्या आहेत ज्या आपल्याला लागतात जगण्यासाठी त्याची प्रमुख गोष्ट अशी की त्या व्यक्तीला त्या कुटुंबाला वर्षभर रोजगाराची संधी असली पाहिजे की त्याला काहीतरी उत्पन्न मिळाले. दुसरं त्याच्यासाठी अन्नाची सोय त्या ह्याच्यात झाली त्याची एक सिक्युरिटी एखाद्याला. दुसरं निवार प्रत्येकाला या देशामध्ये जर जगायचं असेल तर त्याला निवाऱ्याची गरज आहे. दुसरं आरोग्याच्या किमान गरजा, प्राथमिक आरोग्य आणि त्याच्या नंतर, आणि शिक्षणाच्या काही मूलभूत सोयी. हे 5 अधिकार आपल्या जगण्यासाठी प्रत्येकाला लागतात. आणि त्या अधिकाराच्या दृष्टीने म्हणजे इथला जगण्याचा अधिकार आपण मान्य केला की या सगळ्या अधिकारांना घेऊन आपल्याला सगळ्या गोष्टी शासनाला त्या पद्धतीने त्याचे कायदे, त्या गोष्टी मिळेल याची हमी, या सगळ्या द्याव्या लागतात. आणि त्या दृष्टीने आपण बघतो की सगळ्या याच्यामध्ये कायदे लागतात. पण मागच्या 24 वर्षाचा माझा अनुभव असा आहे की कायदे खूप चांगले आहेत, खूप वेगवेगळे कायदे आहेत, पण त्यांच्या अंमलबजावणीमधला सगळ्यात मोठा अडथळा आहे. आणि त्या अंमलबजावणीमध्ये ज्यांच्यापर्यंत ते पोहोचायला पाहिजे, म्हणून तुम्ही विदर्भात सगळेजण नेहमी बातम्या ऐकता, मालन्यूट्रिशनचे डेथ ऐकता तुम्ही, पोषणाचा आपण सतत तो प्रश्न आपल्या विदर्भामध्ये गाजत असतो. आणि आता पावसाळा सुरू झाला की तो प्रश्न प्रामुख्याने येतो. रोजगार हमीचा कायदा महाराष्ट्रात तर जुना आहे, आता केंद्राने याच्या बाबतीतला कायदा केला, तर त्या कायद्यामध्ये तुम्हाला हक्कानी काम मिळत नाही, त्याची फार स्थिती वाईट. अन्नधान्याच्या बाबतीमध्ये रेशनमधनं योग्य पद्धतीने गरिबांसाठी अन्न मिळावं, तर अशा खूप कायदे आहेत की जे कायदे झाले आहेत, पण त्यांच्या अंमलबजावणीसाठी वेळोवेळी तुम्हाला खूप अडथळे निर्माण होतात. आणि म्हणून ते योग्य रीतीने व्हावे याच्यासाठी आपल्याला एक ॲडव्होकसी करावी लागते. आणि ती कोर्ट असं एक माध्यम आहे की यांच्या माध्यमाने आपण याच्या विरुद्ध ते नसेल होत तर ते प्रॉपरली व्हावं, त्या दृष्टीने या सगळ्यांची गरज आहे. म्हणून आपल्याला एकीकडे लोकांचे लढे म्हणजे लोकांकडनं ती मागणी अंमलबजावणीसाठी एक ताकद उभी करणं, आणि दुसऱ्या बाजूने कायदेशीर त्याला सपोर्ट, कारण हा सगळा चौथा स्तंभ आहे आपल्या लोकशाहीच्या याच्यातला न्यायव्यवस्था, आणि तिचं फार महत्वाचं आहे. खूप गोष्टीमध्ये तुम्हाला लक्षात येईल की आता न्यायव्यवस्था स्वतः कोर्टाने आपल्या काही गेल्या. मालन्यूट्रिशनच्या महाराष्ट्रातल्या केसमध्ये महाराष्ट्रातील हायकोर्टचे जज आहे त्यांनी स्वतः ही केस हे केली, आणि त्यातनं ही पूर्ण मग मालन्यूट्रिशनचा प्रश्न, त्यातलं कमिटी, त्या कमिटीचा आता सदस्यपद आहे महाराष्ट्राच्या, ती नेहमीसाठी मॉनिटरिंग कमिटी त्यांनी हे केली की या सगळ्या योजना व्यवस्थित होतात की नाही, आणि त्या पद्धतीने त्याचं संशोधन मग शासनाला वेगवेगळे त्या दृष्टीने सुधारणा करणं कायद्यांमध्ये. तर अशा पद्धतीने काही वेळेस आपल्याकडे आपण बघतोय की कोर्ट स्वतःहून या सगळ्या याच्यामध्ये कॉलेज इथं बसलेले आहे, ते मागच्या कितीतरी वर्षापासून राईट टू फूडच्या संदर्भाने एक केस सुप्रीम कोर्टामध्ये पुष्कळ वर्षापासून चालू, त्याचे कमिशनर नेमले, त्याचं रेग्युलर सुपरव्हिजन होतं, तरी पण आपल्याला या सगळ्या मुख्य मूलभूत जे अधिकार आहेत ते मिळण्यासाठी सुद्धा अडचण होतं. म्हणजे ज्या गरिबांना योग्य पद्धतीने अन्न मिळायला पाहिजे, एकीकडे आपल्याकडे सगळी गोदामं भरून आहेत अन्नधान्य, म्हणजे त्याची अडचण आहे असं नाही, पण ती योग्य पद्धतीने लोकांपर्यंत पोहोचणं, त्याची यंत्रणा कार्यरत करणं, तर त्याच्यात जे खूप अडचण आहे. आणि म्हणून मग आपल्याला या सगळ्या त्या दृष्टीने हे करावं. आणि म्हणूनच आता तुमच्या नवीन सगळे जे वकील मित्रमैत्रिणी आहात, काही वर्किंग आता याच्यातले काही शिकत आहेत, तर तुम्हाला या सगळ्या मुद्द्यांच्या बद्दलची माहिती व्हावी, आणि पुढे मग आपल्याला नागपुरात या संदर्भाचं केंद्र कसं सुरू करता येईल याचा विचार व्हावा. एवढं बोलू मी माझे 2 शब्द संपर्क जय हिंद.
Morning everybody. My name is Holland Gonsalves. I am from the Human Rights Law Network, which is an organization in many parts of the country, but also in Bombay and Pune, but not as yet in Nagpur. Now, most of you are law students, isn't it? Most of you law students. How many of you are final year law students? Quite a few. And how many of you are lawyers today? Can I just have an idea? How many lawyers in the hall? Can you just put your hands up, please? Just put your hands up. Should I? Okay, good. Right. When we came from Delhi this morning, we saw all the lawyers in safari suits waiting to welcome the judges who were coming for a bar council meeting. And I was telling my colleague Director Patel that if only our lawyers showed as much interest in legal aid and human rights as they show in, felicitating judges, there would be a big difference in the country. I remember coming to Nagpur. I used to come to Nagpur quite a bit actually earlier. I used to practice in the Bombay High Court for many years. I can tell you a little bit about me. I was an IIT graduate actually. I passed in 1975. And after passing my IIT, I was very influenced by the developments that took place during the emergency. The emergency was 1975, right? You remember? 1975, not bad. The emergency was 1975, and in Bombay they were throwing the railway workers out of their homes because the railway workers were demonstrating against the emergency, and orders were given to lock their homes in Bombay. So they took all their baggage, threw it out, threw the families out and locked their homes, and we were very agitated over that. And some of my colleagues in IIT actually were trying to break the strike of the railway workers. So there were front page photographs of IIT students driving the trains. Can you imagine? You're not authorized to drive trains, but they participated in that propaganda against railway workers. So front page photographs, IIT students drive trains and so on. And so we were active in mobilizing the railway workers. We were very active in those days, and I got a little radicalized while I was in IIT. I think in my third and fourth year of IIT, I met with people who were talking about social change and so on. And after my IIT, I joined a slum group, and I worked in slums for many years, organizing slum dwellers and taking out mochas of slum dwellers. There were many demolitions and evictions taking place also in those days. So 70, and after that I joined Datta Samant. Many of you will know, I think, Dr. Samant, right? Dr. Datta Samant, he was quite a fiery trade unionist in those days. He was shot dead. Many years later. But he was a very fair and an active trade union leader. So I joined him and I worked with him for many years as a labor organizer. I started my practice in the labor courts in Thane, then moved to the labor courts in Bombay, then went to the High Court for many years, and then moved to the Supreme Court in 2001, 2002. That is my history. I did a lot of activism, and I must say, and I think this is important for all of you, and I think over the next 2 days we will discuss much of this. It is very important for young students to learn life not just from the point of view of the books and your lectures and what your teachers tell you, but to learn of life from the reality of the world around you. And I can say with a certain degree of confidence today that whatever little I know and whatever little expertise I've developed, and also how I look at the world, how I speak, how I interact with people, how I'm able to understand things, how when a judge takes a particular approach, I'm able to argue with a certain degree of, passion from inside, is all due to whatever little background I have, or had and have, of dealing with people who in their daily life struggle just to stay alive. The working class people struggle to stay alive, the farmers struggle to stay alive. Women suffer a lot of indignities in their lives, a lot of violence. Dalits suffer a lot of violence in their lives. And if you interact with them, some of that passion of those people actually comes to you, right? So in a sense, a lawyer is a learner. A lawyer is an absorber. A lawyer is not so much a teacher and a guru. Of course, we like to pretend that when clients come to us that we are teaching them and we are doing things for them. But actually, every poor client who comes to you, and particularly poor clients, working class clients, Dalit clients, when they come to you, they are actually teaching you. They're teaching you about life, they're teaching you about struggle, they're teaching you about law, how law operates against the poor. They're giving you a puzzle. The puzzle is the puzzle of their own life. They're giving you a puzzle. And they're telling you that, look, we are working class people, we are living normal lives. Why is the government harassing us like it is harassing us? Why is the police being so brutal to us? Why is caste oppression so terrible? Why is women's oppression so horrible? We have laws, we have constitution, we have these grand judges. Yet, we are without legal aid. They're giving you a puzzle. So actually they are teaching you, and a lawyer tries to unravel the puzzle. When she tries to go to court and do a case, she's unraveling that puzzle. She's actually learning in a sense, or he's learning in a sense. So, the interaction with society and the growth of a lawyer, I learned very much, and I came to start the Human Rights Law Network in '89 with 3 people in Bombay. And then slowly we went to different cities and we built the Human Rights Law Network. Today we have 250 young lawyers and activists in different parts of the country. We have a big office in Bombay, we have an office in Pune, where my friend Kanti runs the office in Pune. We hope to run an office here in Nagpur, but we want to find some young people who are dedicated to working for the working people. Right? That's the reason why we've come here. Many of the lawyers will be coming in a little late because they've gone to say hello to the judges who have come. So we can't rush them that. I would prefer that they would be here, but they will come by the afternoon or so. We'll come. But we'll start with our sessions as we see. I am really grateful to Satish Nobilwar for helping us organize this meeting. He's done a lot of work on disability rights and health rights and so on. We're grateful for the collaboration that we have, and not only for this meeting, but I would say we would collaborate in the running of the center in Nagpur for a long, long time to come. And of course, all of you must, many of you are young, so you may not know, but this is Daireshi Patil, who is sitting here, senior counsel, and one of the most active persons in our country on criminal law. I have learned so much of my law, whatever little I know, by sitting in his meetings and listening to him and so on. And he's really a person who has inspired many generations of young lawyers, many, many young lawyers in criminal law. This session will start immediately after this, and we are really happy to have him here for the next 2 days, and he will interact extensively with you, not only on criminal law, but he's also an activist like I am. So he will also tell you about the activist attitude and the activist approach to law. So let me, before I end, just clarify that an activist approach to law does not dilute in any way the need for a professional approach to law. Right? When you say you're an activist, it doesn't mean that you read less. It doesn't mean that you study less. It doesn't mean that you'll argue equity, not rights. You understand what I'm saying? When we go before a judge and we are fighting for the rights of the people, it doesn't mean we ask the judge for mercy or pity, or the crumbs off the table. We're not asking for those things. The working people have rights. They have entrenched rights. And we are struggling and we are fighting for the enforcement of those rights. So when you appear for poor people, when you appear for working class people, you have to study much, much more because the bias of the whole system is against you. Right? Property class people are against you. Property interests are against you. Lawyers will come, you stand up for the working people, you stand alone. On the other side, you find lawyers, a battery of lawyers, appearing for the employer or for Rahejas or whatever, the builders and so on. We'll have a battery of lawyers. That was in the Goa High Court just 3 days ago, fighting the SEZ cases, where the people have stopped the work on the SEZ, where the government has taken the land, agricultural land. You won't believe it, agricultural land, they took it at 20 rupees a square meter. Lakhs and lakhs of acres of land, 20 rupees a square meter. Then the market price is 3,000 rupees a square meter. They gave it to Rahejas and all these people at 600 rupees a square meter. Take it from the tribal at 20 or the farmer at 20 rupees a square meter. Give it at 600, market price is 3,000. So the remaining money will take in back and keep it at home. Former chief minister of the board. So here I am appearing for the SEZ persons and appearing for all these companies. You have 10, 15 lawyers coming from all across the country fighting for them. So remember, when you fight for the working people, you're not fighting an equity thing, right? Although there is equity, no doubt, you're fighting for the rights of people, and when you fight for the rights of poor people, you have to study 10 times more. You have to prepare much more. You have to study your case law much more, because a greater spotlight will be put on you. All that people with money have to argue is, sir, I've spent so much money. That's all that they say. I've spent already so many crores of rupees. Government has given it to me. I've got all my clearances. I've spent so many crores of rupees. Look at these people. They're coming so late. And then you have to prepare. So preparation much more, study much more care and attention to your cases. And that you will do only if, in your hearts, you have a commitment to your case. You have a commitment to your client. You feel the suffering of your client. You understand? He's not giving you money, she is not giving you much money, maybe a little bit, maybe 1,000 rupees they pay you. Why would you feel for a case and argue a case? Why? Why would you stay up till late night, get up early morning and fight for the rights of tribal people and fight for the rights of Dalits? Why? Only because you have a feeling. And you get that feeling only if you allow the working people to give you that feeling. Being among them, working with them, not feeling superior to working people because you are middle class. You understand? Understanding that from them you will get the learning that you need. And when you feel in your hearts that yes, the struggle of the working people is justified, I am on the right side. When you feel that in your bones, in your body, when you feel it, then your arguments will become different. The way you speak, the way you react, the way you answer a judge when the judge asks you questions, all your mannerisms, all your speech, all your feelings will communicate to the judge. Then the judge will say, this young lawyer has studied and this young lawyer seems to feel for his client. You're able to communicate suffering of people, right? Denial of rights, you're able to communicate nicely. And so, my dear friends, that is our interest in coming to Nagpur. We are very keen to build from among you, to find among you some young people who want to work very hard. Your parents will scold you, let me tell you. Your parents will scold you. What are you doing? We have spent so much money educating you. And what are you doing? Going with some human rights law network and doing case for some tribals and going to Dutch-Shiroli and going some riffraff. They will scold you, let me tell you. And if you're a woman, you'll have a harder time. If you're a woman, you'll have a harder time. And we are looking also for women. In our organization, 80% of leadership is women. Everywhere, in every state, it is women who are leading. So, we know that talent will come from within. Some men also will be there, let me tell you. But, don't forget. But we are very partial towards women. We feel that the future is with women. But women will have a very tough time. Their families will say, oh, you have been educated as a lawyer. What is all this? You are traveling here, you are doing this, you are doing that. You should get married. Don't go for all this. So, we do hope over the next 2 days to introduce you to a variety of issues, to some topics, to look at law from a totally different way. Let me tell you the identical meeting taking place where all the judges are present. They will discuss everything under the sun. Everything under the sun, except justice for the poor. They will all dress up in safari suits. Of course, some of our judges will have nice suits. They will all come. There will all be garlands. There will all be lighting of the lamp. They'll all do all this tamasha. And they will spend 2 days, and they spend lakhs of rupees of scarce public money. But they will discuss everything but justice for them. And it's a shame that our whole movement, our legal movement, our bar associations and our bar councils have forgotten the way also. Our judges, of course, have forgotten their way long back. Slowly we try and persuade them. There are some good judges, but many different judges these days. And so over the next 2 days, we will give you a little exposure. And I am proud to say we will give you a very good exposure because we have some of the finest lawyers coming here to interact with you over the next 2 days. A fine exposure of the other side. The other side. What does it mean to really use your law in the struggle for the majority of the population that needs it most? Thank you very much.
Our next session will be
We have Praveen Wah, we have Ika Mahajan, Surekha
Mahajan, Surekha Darvi, Vaishali Patil. We welcome you all. And Praveen Wah. We welcome you all. And Mr. Vilas Mungar as well. Would you like to start with
before I start with my topic, I was listening very carefully. I've been listening to him. Our friendship goes back to a quarter of a century, Colin and I. You should remember 3 things mainly he made up. He referred to the Bar Council meeting. This is a passing reference I am making because I am an insider. I was in the Bar Council of Maharashtra and Goa for 19 years. I was in the Bar Council of India for 12 years. I was its chairman. So I know everything that goes on there. And he said that they would discuss everything except legal aid to the poor. He was wrong. Because I remember as a baby in the Bar Council of India way back, that was my first meeting, which was organized when I entered into the Bar Council of India. It was at Shimla. Those were summer days, so naturally you had to have cool atmosphere around, so you could think coolly. The topic was legal aid to the poor. We were seriously going to discuss legal aid to the poor. The venue was the Oberoi on the mall in Shimla. If you have seen the mall, you know the mall, MALL. It's not Mart. In Marathi we know Mart. It is that, it is uncultivable sort of land where only the cattle could graze. That is Mart. But mall is the place where the British madam and her consort would hand in hand in the evening would take a walk. That was the mall. Now that is how, even in a small place like Satara from which I come, there is a mall in front of my house because it was camp. It was a British camp. So there used to be British officers who were stationed in Satara, and there were some German prisoners during the Second World War. And the British couples would, probably, I don't know, I wasn't there, so they would take a walk in the evening in a place, small place like Satara. So that was, he was wrong that they don't discuss that. They discuss it, but in a very conducive atmosphere of the overall, that they discuss such topics, the Bar Council of India. Actually had been a member of the Bar Council of India, therefore I don't know whether really I am supposed to disclose these things which go on inside, but that's irrelevant according. One second thing which he referred to was, and which is very necessary, that merely because some of you would be inclined to join the HRLN and therefore would be representing the poor. I'm just categorizing sort of in a very elementary manner. I always say that if you're representing the poor does not mean as their lawyer you should be poor here. You have no right whatsoever to be poor here merely because you are going to represent the poor. It becomes your added duty, I would say, when you are going to represent such a class of society, that you should be well equipped because you are pitted against much better known lawyers, much better paid lawyers, and it does help the other side. Case law does play a part, including in the Supreme Court. You should see actually on Mondays and Fridays in the Supreme Court where case law has its biggest role. When very known lawyers, Indira Jaising used to say about the earlier evening, these very lawyers have a party with the same judges, and the next morning they appear, my lord, they would bend down better than you people would be able to do. And the judge is, again, don't ever forget that judges are also humans. They have all those faults, they have all those weaknesses, they have all those confusions of a human being. And never be under a wrong impression if you were to think that judges are not warmed by the same summer, they are not they don't feel the cold by the same winter as you people feel. And therefore it is very necessary to imbibe into your mind first lesson, that judges are as human as anybody else. And if you were to be told by somebody that once they become judges, overnight they leave behind their background, they leave behind their class background, they leave behind their prejudices, you would be living in a fool's paradise. They carry forward that luggage or baggage or whatever. Baggage is the more modern word instead of luggage. Luggage has been left behind. Now it is baggage. So all that baggage which they have collected over the years, over centuries I would say, over generations of their own family or their own class or their own community, they carry forward till they go whatever, cremation ground or burial ground or whatever. Therefore, don't ever rely upon judges being very, very impartial. It's all that class. You know, lawyers always discuss a particular judge is an acquitting judge, or a particular judge is a convicting judge, a particular judge is a pro-land or pro-tenant judge, pro-industrialist or pro-worker judge. All these confused come because they carry forward their own earlier emotions. That also has to be remembered. Number 2 point which he made out was that you can't really fight this battle unless you have a conviction. It is impossible to fight with any more conviction than you could really muster unless you have a conviction of your own views. And what he wanted to add was that it is not for compassion that you are asking the judges from. No, it's not compassion. You are asking for the rights of the people. And rights of the people really don't fall from the heavens. Please remember, human rights don't fall from the heavens at all. They are the opportunities made available by a given class society. Because we are living in a class society. We are not living in a class-ridden what you call eliminated society. We are not living in a classless society. We are living in a class and caste and religion-ridden society. That's the unfortunate part of the whole situation. Therefore, unless you have got that conviction, and therefore you are asking not compassion from the judges. Even compassion is not available. Even compassion is not available these days. But you are asking or fighting for the rights of people. That is the second thing. And the last thing which he wanted to add was that he did not pose that question. I am posing that question, and maybe tomorrow would be a better day because the topics are different. This is a very specific topic, criminal law. But then tomorrow maybe we are discussing in the morning session and the concluding session as to whether really all this is possible. Whether this conviction is possible. Whether this fight for the rights of the people within the human society is possible. Whether really it is possible to change this society with the help of the law. Because if we were to believe that, we would be losing sight of the very concept of law, very meaning of law. I am not concerned with definition of law, like our law professors, some of them by heart those definitions. You ask a question 498A, he would go on, without realizing what was behind those provisions. Why those provisions were required to be made in the first place. Why that cruelty to women which was required to be put into a statute book. Why could the society on its own not meet the situation? Now all that, I am not talking about that. We will be forgetting the very essence, the very nature of law if we were to believe that only with the instrumentality of law we could change society. That has never happened and would never happen. Please remember that. We would discuss about this much more in details tomorrow. What he wanted to say probably was wanted to actually pose a question which he might pose tomorrow is it then possible to have that conviction if you become just professionals? If you remain apolitical, is it possible to take a stand with any conviction if you remain apolitical? And if you are being proud of the fact that you are apolitical. Nobody is apolitical, please remember. No judge, no human being is apolitical. When a person says that don't mention politics, we don't want to discuss politics. He is discussing politics. Because he doesn't want you to enter into a dialogue about politics. He doesn't want to discuss politics. He again, what Karl Marx had said, he wants opium of the masses. He just wants you to be just masti mein raho, see the IPL matches, see the movies, see those stupid Kyunki serials, see those dance competitions. If present dance competitions are not enough, then Dada Dadi, Nanya Nani, and many more, the entire family and whatnot would be there. And there are about 200, I think at least minimum 200 movies a day, which are being dished out to us by various channels, 70 channels, 80 channels, 100 channels on the television. Therefore, it is just not possible to take an apolitical line at all. This is number one. Number two is that whether our friend was talking about right to food. Now, right to food, or there is another topic, right to health, would be available, doesn't depend really only on the production of food grains. It doesn't really depend upon faulty distribution. No, it doesn't. Poverty is essentially a political question. Poverty doesn't happen because there is a faulty distribution, because the government godowns are full and rats are dying of overeating. That doesn't happen because of faulty distribution. That doesn't happen because the government bureaucracy is inefficient. That doesn't happen because government bureaucracy or the governmental machinery is corrupt. No. Poverty happens because the essential question would be who controls the political power in a given society. And whether they have, it's not a question of lack of will. It's not a question of lack of distribution, lack of maybe trucks or railway wagons. No. It is a question of which class controls that society. And therefore, who controls the production, the manner in which the production would be made, the manner in which it would be distributed, the manner in which who would be attended to first, and the manner in which, if necessary, the state force or the force of the state would be used. Therefore, please remember, there is nothing which is apolitical. Not even a simple case is apolitical. It has some background which would be traced back to what is the situation in a given society. Now, keeping this in mind by way of a background, just always keep this in the background. It always should be at the back of your mind when you think, you analyze. When he said analysis, what he meant was that you are, as lawyers, you are not going to read out the provisions of law. No, not only the provisions of law. How you interpret them. How you go behind that law and tell the judges what was the object of enacting, what was the alleged object of enacting those laws. Because the very people who make those laws keep those loopholes in the law, very deliberately made. I can give an illustration before I go to my subject proper, but this is very necessary according to me because you are fresh minds. You know, while our freedom movement was going on, many people think that the constitution which Dr. Babasaheb Ambedkar wrote in 1950 was the brainchild of Nehruvian sort of thinking on law or on politics. No, that's wrong. A number of things had gone into the freedom movement of ours. The essence of freedom movement, which that man in 1920 realized, Mahatma Gandhi, that unless you make the common man participate in the freedom movement, unless you make him believe, I'm using the word believe, because that was also make believe. You make him believe that he has something to lose or gain by the freedom which the country would be getting from the British, you can't really succeed. And therefore certain slogans were given. The most important slogan which the old people remembered was land to the tiller. Land to the tiller. So that the landless would have some interest in getting freedom or fighting on the side of the freedom movement. When we got political freedom in 1947, then the constitution came in 1950, people started asking what happened to that slogan. And therefore in the mid-50s came those land legislation. You know, Tenancy Act, Selling Act, this Act, that, Jamindari Abolition Act, so many laws came. And there were loopholes there in that land. I can give you one of the worst illustrations of the loopholes. Even a cat and a dog could hold, and the God could hold. God has a lot of land. God is the greatest landlord, I think, all over the country. So God could hold. God means humans who are the so-called priests or whatever, looking after that land. Then the question of sealing came in Maharashtra, for example, as to whether really what could be the unit, what family unit would be holding that land. One of the loopholes was that if husband and wife are divorced, the wife would be a separate unit, and therefore she would be entitled to hold similar acreage as her husband. There were bogus divorces which were given. You know that in a place like Satara district, Pune district, or Sholapur or Kolhapur or Sangli, which are supposed to be the sugar belt area of Maharashtra, the so-called forward area of Maharashtra, the western Maharashtra, from where I come. There are instances of very middle-level sort of leadership of the Congress and other ruling parties, where the man has given a divorce to his wife. Thereafter, they are living together, they have had children thereafter, but on paper they were divorced and therefore they were entitled to have two separate units of land holding. Now look at that law, which makes a mockery of the object behind making those laws. Now all that was done, why was it done? Was it negligently done? Was it done because the lawyers or whoever drafted those secretaries in the Mantralaya who sit there in that particular department, they were lacking the necessary expertise and therefore it was done? No, it was deliberately done so that the holding could remain, bigger holding could remain within the family. Now remember, therefore, as an instance I gave that, I can give you dozens of instances of laws which were faultily made, deliberately made so that laws don't fall from heavens. They are made by a given ruling class, and therefore it always tilts in favor of the interests of that class. That definition of law should never be forgotten by you. Forget about the traditional definitions which you have learned in the law colleges. Those are okay in the books. It doesn't happen. And then the last thing which he wanted to tell you was that ultimately you learn from your own clients, from your own that strata of society who you are representing in courts as their lawyers. What he wanted to say was that life is the best teacher that anybody could have. Life teaches. It's not only the colleges, it's not only law colleges, or not the definitions which you will be finding in those books, but outside in life that you will be getting lots of more definitions which are much wider. Interpretations, that faculty which you will have to develop to use certain situations by analogy. You use another law, and by analogy you use that law. That innovative idea, I will be taking that illustration later on when I turn to criminal law. That with the strongest chain and kill somebody or injure somebody, he can't be allowed to argue that I am not responsible because I took the maximum care to tie down this animal. The answer would be no. You are absolutely liable. It is a question of strict liability because you bring onto your property something which has the propensity to escape. You bring on something on your property which wasn't there, and it is dangerous, likely to escape and likely to commit mischief. If you bring such an animal on your property, then you are strictly liable. Use that in environmental protection law. Why not use that? Why should we have MC Mehta versus Union of India or whatever, the chain of cases? MC Mehta is one of the lawyers practicing in the Supreme Court, and he is fond of going in writ petitions in respect of this environmental protection. Now, why not go use Rylance versus Fletcher? A man has set up his factory, which wasn't there, and is releasing its effluents into my drinking water. That property is upstream. My drinking place is downstream, and he is releasing his effluents into that river, and I am supposed to drink that water downstream. He has brought a tiger which was not there. He has brought a tiger which has a propensity to escape and commit mischief. and therefore is strictly liable. Why not catch hold of that industrialist on the basis of Rylands versus Fletcher rather than the environmental protection law or MC Mehta versus Union of India or whatever? Use your brain and innovate is Donoghue versus Stevenson. That also you must have. The snail, the dead, decomposed snail remnants were found in the bottle of ginger beer, which was an opaque bottle. It was not a transparent bottle, but an opaque bottle. You know, this bottle was, this ginger beer was being drunk by these friends in a pub, in a bar. And when they almost finished that bottle, at the bottom of that opaque bottle, they discovered that there are some remnants of a dead snail. And that led to some of them. And they filed a suit against the manufacturer and against the retailer. The defense of the retailer was that no, I'm not responsible because it was manufactured by somebody else. It was brought in a sealed condition and I sold it in the sealed condition. You know, these barwalas have a habit of bringing that sealed bottle to you and they say, oh, sufficiently chilled. You touch it and you say, yeah, that's sufficiently chilled. So you can open it, and he opens it in your presence. So it was done accordingly, and he said that it was opened in the same sealed condition in your own presence. There was no question of my having contaminated that bottle with the help of a snail or whatever, and it was the manufacturer who alone was responsible. I am not responsible. It was that no. There again a strict liability was the view taken by the court. Use it in the consumer protection law. Use it in the consumer protection law. Now all these are therefore matters of young mind using their own innovative ideas. By analogy, you use criminal law, you use the law of torts in order to achieve at some sort of justice for your client. Now that was the short point which I was trying to make out. Now as far as criminal law proper is concerned, there are so many decisions which were given at different points of time by the Supreme Court. Different judges taking a good view. I can just narrate certain facts and you can immediately jump to you would even remember the names of those cases. You can't really use only criminal law. You could in the trial courts. But when you go to the High Court, you go to the Supreme Court, it is Article 226, Article 32 which would have to be used under the Constitution. But simultaneously with the given criminal provision, you would have also to take help of Article 21. So again, Article 21 and the relevant criminal law which you want to use are again Siamese twins. Article 21 would be handmaid of achieving justice. Article 21 would be the carrier, would be the conduit for using this criminal law in favor of your client, in favor of the citizen concerned. Therefore, Article 21 and of course these provisions 226, 32 of the Constitution, Article 21 and this. Because ultimately, what is Article 21? Right to life. And what is life? Life doesn't mean like your animal existence. Life means human existence. And therefore, whatever is necessary for all those nuances of human life or human, what you call human race, all would be included in right to life. And therefore the Supreme Court on criminal side had taken the view, Justice Krishna had held whether it is bail or jail. Now that was one of the earliest cases. And when you cite these days, you cite Krishna here. Colin would cite Krishna here. Justice Krishna here. We have seen many of the judges in the apex court laughing, not smiling, laughing derisively, as if Krishna Iyer has become dated. The ideas which he propagated have become dated. Those ideas would never be dated, my dear friends. They would never be dated. And therefore it is for us to keep them alive by saying, no, this was the correct view of the law that was taken. What you are saying is wrong. Not in so many words, we are in a workshop. But this is what you have to convince the court. No. What was the object of this law? Why this law was made? What has to be achieved by making this law? And if it could not be achieved by the traditional method, then the interpretation, the innovativeness which Justice Krishna Iyer had made has to. What exactly is that? What did he say? How do you justice. How do you really give his human rights to an individual, to a citizen, by using Article 21? And then in that respect, he said jail or bail. He said that if a man comes in a morcha to Delhi from Tamil Nadu and is arrested there, do you insist that the surety should be from Delhi? How do you expect a man from Tamil Nadu who has come all the way to 2,000 and 2,500 kilometers to Delhi to participate in a morcha against the inhuman policies of the government? If he is arrested and the court in Delhi asks for bail with a surety of Delhi, it is impossible. The man would be just sitting in jail. That's all. Therefore, he said bail or jail. What was the principle? What was behind this asking for this bail? The basic thing is that everybody is entitled to bail, not that everybody is to be sent into jail. No. The basic concept is to give him bail, unless there are certain reasons why he should not be granted bail. Murder case, this law, this, that, there is a lot of evidence, an offence punishable with death or life, all those things which are mentioned from 437 to 439, all those would be Code of Criminal Procedure would be considered. But the basic concept is bail and not jail. The second thing, which was also propagated by the Supreme Court in one of the cases, was that if a person is languishing in jail, he has no lawyer, he has no money to engage a lawyer, he has no relatives to help, he has no friends to help, and he sends a postcard and requests the Supreme Court, the apex court or the High Court, that this may be treated as a writ petition. Why those nuances required? Whereas, you know the Bombay lawyers. Whereas, without prejudice. These are the two favorite terms with Bombay lawyers. Whereas, and then without prejudice. All that, without prejudice, and all that. Yes. Therefore, all that was treated as, there was a situation where the Supreme Court decided or was consciously holding that even a postcard would amount to a writ petition. It could be treated as a writ petition. Then there was that Visakha versus State of Rajasthan, versus State of West Bengal, where directions were given, those 11 directions were given to the authorities, to the police and to the jail authorities, that certainly, the person has to be, his relatives have to be informed immediately, or if there are no relatives, then the human rights organization within that area has to be informed, then he has to be sent for compulsory medical checkup, etc., etc. Those are the illustrations. The point is that any given criminal law, whether it would be really used for the purposes for which it was originally supposed to have been enacted, would ultimately, whether it should be left to the sweet will of the judges, or whether really there has to be a movement from outside pushing for a uniform approach in cases of human rights and violation of human rights. That is the point really that I was trying to make out, that in criminal law, hundreds of illustrations could be taken. Illustrations, there are plenty. But the point is that criminal law, as it exists within the four corners of the existing society or existing economic order, whether we could use as activist lawyers, that's the point. That's the point I was trying to emphasize. Maybe tomorrow we would have more time to expand on a different area altogether. I was only on certain limited examples of criminal law that could be used in favor of the citizen for whose human rights you are agitating before the court. Now, with these words, I would sit down, because the Madhikari also has to expand and put before you his own views on this topic. And there are many more speakers also listed for the day. Thank you very much.